Good morning, everyone. My name is Mike Liccardo, and I'd like to thank you for joining our webinar today. This is another in ShareVault's webinar series, and today's topic is driving quality during eDiscovery. Today's presentation is especially timely given today's economic climate and future regulatory and compliance trends. Litigation support, including the eDiscovery process, has become a significant portion of total litigation costs with the accelerating usage of electronic information management and new internet communication services. Corporations must become more proactive and litigation ready by utilizing best practices and technologies to minimize eDiscovery costs. Now, during the presentation, your individual audio will be muted until the question and answer session begins in order to minimize background noise. There will be a question and answer session after the presentation and demonstration, and you will be able to submit questions via the question box located in your control panel. Now let's get started. I'd like to introduce Ed Lee from Deloitte, who will begin the presentation.
Good morning or good afternoon, as the case may be, wherever you are. So, as Mike said, the landscape of discovery has not necessarily changed as much as it's accelerated. We see an increasing volume and velocity of activity around litigation, especially the discovery process. And many attorneys that I deal with struggle to get their arms around how to address the basics from a process standpoint. They look to bringing together the right teams, the right technology, and the right processes in order to make sure that quality is part of their discovery plan up front. And then once they've gotten their hands around their planning from a quality perspective, they want to make sure that everything that they do is defensible from the beginning to the end. So what we'll talk about today is how you go about pulling together the right process, the right team, and how you can enable that through tracking systems, some of which are going to, by definition, be manual in today's world, and some of which are going to be very beneficial from a perspective of technology. So before we get started, there's a bit of background about me. My practice in the Deloitte Financial Advisory Services Group really is focused on helping the Office of General Counsel and the Office of the CIO deal with crisis, compliance, and deals. In many cases, you're familiar with how deals benefit from technology and e-room type approaches, but you may not be as familiar with what our practitioners do whenever we're looking towards crisis and compliance. My background is I'm an attorney by training and trade, and for the past 15 or 16 years, I've worked with General Counsel and the Office of CIO to deploy solutions and build programs that help companies drive compliance and discovery effectiveness. Right now, one of my main roles is supporting a team of over 120 discovery professionals on arguably the largest multi-district litigation in the United States history. So that being said, I tend to have a point of view around what people can and should do in the realm of eDiscovery. So a bit of disclaimer, it wouldn't be a legal presentation if we didn't say what we're not going to do. We're going to talk a lot about some things that can give you insight as to the leading practices during discovery, but what we're not going to do is give any legal advice. We're not going to talk about specific instances. So if you do have any questions about how you can use these practice tips or techniques in your own world, I would encourage you to reach out to your counsel. So today's goals. By the end of our discussion, you should be able to identify a couple of key things. One, what do we mean by defensible eDiscovery? That's a term that is floating around lately, and people are looking for ways to make sure that the quality they put into their process ends up being a defensible discovery protocol at the end of the day. We're going to talk about key challenges. Those key challenges begin in the scoping and planning session, and they flow through to the critical elements of the discovery process beginning with legal hold and all the way through to the production of documents to third parties and opposing counsel. Finally, we'll talk about the process being tracked and defensible through activities that your team may be engaged in, the types of questions that you're asking yourself, the key stages and control points that you may want to consider, and your documentation and defensibility strategies. So, first of all, that first goal that we had, characteristics to consider. When we think about defensible eDiscovery, 6 things come to my mind immediately. One is the activities you're engaged in should be tailored to the size of the matter, the risk that's involved, the needs of all the parties, and the circumstances that you find yourself in. A particularly small matter between 2 litigants may not rise to the level of needing a robust team or robust tracking mechanisms. It may be something where you can track your activities in a spreadsheet or in an activity log, many times keeping the information in the attorney or paraprofessional's email to keep the chain that way. Whereas a large multi-state, multi-district litigation may not be able to be tracked that way. You may quickly outgrow an activity log or the ability to dig back through your email in order to make sure that you can account for what activities you've done. So being able to tailor your activities to the size, risk, needs, and circumstances is the first consideration. Expertise is another thing to consider, making sure that you draw from an appropriate range of professionals. If you think about your client base, some of the things that you'll need from an expertise perspective are going to be legal expertise. You'll want to engage inside counsel and outside counsel at appropriate times to be able to get their input and specialization. You may also need expertise from within your client in terms of the technology at play. Many different companies deploy email systems differently. So if you think you understand the ins and outs of one client's email system, it may not apply to the next client. Likewise, from a business perspective, people within your client base may choose to organize their information or deal with their evidence in a different way. So being able to draw upon that business expertise across your client base is going to be important as well. The third consideration that we like to talk about is adaptive. So the process that you put in place early on may be appropriate for initial investigations or initial fact-finding, but it may not be appropriate once other litigants start being added or third parties coming into play during your litigation. So being able to follow an iterative approach and allow for learning and correction and update is going to be key. There's nothing wrong with saying, you know, we took an approach early on in the matter that met our needs there, and then we adjusted and increased our capabilities as we went on. The fourth thing to consider is how you measure your activities. I always encourage people to employ metrics to monitor progress. So if you know that you have a certain number of custodians that were initially in scope for discovery, and as you go through that and develop your fact pattern, you find more custodians that you may need to add, we want to make sure that we're monitoring how we're tracking against that and ensuring that the approach that we took early in the matter is consistent in terms of quality later in the matter. Documented, that's another piece to consider. So ensure coordination and communication by documenting your activities so that people can take a look at it and see where you are in the process. And it increases defensibility. You'll be able to look back and have that reference point to be able to say what happened at a particular point in time. And finally, transparent. Making sure that your actions are documented, tracked, and transparent so that as you begin your selection and scoping process all the way through to your production at the end of the day, there's no question about the transparency of your activities. So moving forward, one thing to consider is as you think about all these elements of defensibility, quality matters on both fronts in terms of the civil side of the house, where statistical sampling following a reasonableness approach may be appropriate, versus the criminal side of the house or the regulatory agencies out there, where there's a much different standard that's applied. So back to that iterative approach and that tailored approach, these are things to consider whether your client is involved in a civil matter where statistical sampling is going to be one of the baselines, versus a more robust criminal or regulatory matter where it really is a no file, no data left behind approach. So being able to toggle your strategy between those two and understanding what your client's facing will be important. So scoping and planning activities. Early on, tracking and documentation of your team's efforts in the scoping and planning phase is going to be essential to maintaining the defensibility. You're going to be engaging IT professionals, you're going to be engaging business professionals, and you're going to be engaging lawyers and paralegals in ways that will address the needs of custodial information, non-custodial information, and the preservation and collection strategy overall. So when you sit down and think through the people that may be in scope and the collection approach that you may need to take for their personal information or their custodial information, you're going to be identifying key players and potential witnesses from a fact perspective or from a 30b-6 perspective, and you want to document and track the decisions that you made in that process. You also want to make sure that you're able to show that you've done a reasonable inquiry as to the existence of data or devices. That's what we see in a lot of the cases lately, is courts looking to the reasonableness of your initial inquiry and your education up front around what information custodians may have had. Likewise, that plays out in the non-custodial data too. So being able to understand and document what enterprise data systems, so what large-scale systems like email or document management or records management systems may be in place. Large-scale databases also, being able to make sure you understand what information is out there and then begin to think through what strategies you may employ to pull that information out. Another area of consideration in non-custodial data sources is the third-party information. It may be the case that external service providers hold information for your client, and you need to understand how you're going to go and acquire that information as well. So the key need at this point really is knowing what happened from a fact perspective, when that happened, and then understanding your approach to gathering the data at each step of the process, whether it be the initial collection or all the way through to final production. Beyond the initial scoping process, critical elements of discovery, we've all seen the eDiscovery reference model or the EDRM. That plays a significant part in overall workflow management. But when I break it down, I try and break it down into simple boxes that I know our teams are going to be engaged in. We're going to be looking at the processes of issuing a legal hold and dealing with initial matter management. We're going to be looking at how we do request intake. So requests from third parties are brought in, and we're going to be making some decisions about how we're going to respond to those requests. We're going to go out and collect data. So we're going to acquire that information either from the individuals or from the corporate data systems that may be in play. We're going to transfer that data. We're going to upload the bulk data into a repository so that somebody can do some analysis and processing on it to be able to pull it down to a usable set for our attorneys. We're going to push that through to a review platform where people are going to make decisions about responsiveness, non-responsiveness, and privilege. Finally, we're going to identify a core data set of documents for production, and we're going to push those out. So along this process, you want to be thinking about documenting and determining your strategy for tracking along specific control points. Some of that strategy is going to be based on status reporting, so being able to understand where you are in the process and communicate effectively among your team. Others are going to be in terms of making sure that your activities are defensible, and you can show that years from now. And the third is going to be around multi-matter or multi-production data set integrity. That's a big way to say if I'm producing something to one party, I want to make sure that later if I have to produce the same data set to a different party, I'm using the same strategy, the same quality and decisions. So making sure that you understand the questions you're trying to answer is going to be key. Sitting down to work with your team of inside counsel and outside counsel and thinking through from a status reporting and tracking standpoint, what are the questions that we're going to answer? Common ones are, have we identified all the appropriate custodians? Have we scheduled interviews? Do we know where the custodians are? What follow-up may be needed? Do we know who's represented by individual counsel? And are there any particular considerations around individual counsel representation that we would need to be aware of? Where's the data in the process? So once we've gotten it out of the custodian or out of that corporate data system, where is it in the process? Is it ready to be reviewed? How many review attorneys do we need? Being able to look at the volume of information that you've collected and do some predictive analysis around, do we need 60 attorneys? Do we need 160 attorneys? And then finally, what level of additional QC or quality review are we going to advise? How do we engage our senior partners or our most expensive resources to be able to look at this before it goes out the door? So those are some of the questions from a status reporting and tracking. We talked about the multi-matter and multi-production integrity questions, and then the defensibility reporting really is a roll-up of all of these. So you may need to answer questions 3 or 4 years from now around any one of these matters whenever the court or regulatory body questions your activities early in the matter. Okay, so we'll take a look at each one of these a little bit more in depth. When I talk to clients about the activities up front in legal hold and matter management, really what we're looking at is, has a legal notice been sent? Has that hold notice been sent? Which versions of the hold notice have gone out? Do we have that authoritative list of people or entities that the notice went to? And have we undertaken technical preservation activities within the corporate IT world that will lock down information for these custodians? The tracking mechanisms that we see in place generally for those types of activities are a legal hold system. Some companies have them, some companies don't. A matter management system, again, sometimes you have a robust environment for that. Sometimes it's a collection of Excel workbooks. And then global directory services, working with your IT department to understand what's that global list of people and technology that we need to be aware of. The second key area is around receiving requests. So bringing in the requests from third parties, whether it be regulatory inquiries or formal requests for production, being able to log those and identify the strategy that you're going to take to fulfill those data requests, and then tracking that through. Again, you might see matter management systems come into play here. Oftentimes we see people keeping track of this either in email or Excel spreadsheets. Moving on to data collection and the uploading of that bulk data into our vendors that can do some processing. The data collection piece really is where we get our forensic specialists into play, and that can oftentimes be the most complex area to track. It's where we're adjusting our scope and we're planning, we're changing our plans based on custodian and non-custodian systems as the facts come out. We're interviewing people and making decisions at the individual level on, is this responsive? Do we think that it's something that is important to be able to collect outside of just simply preserving it? At this point, we're also making sure that our legal hold status is confirmed every step of the way, and then through the interview process, through discussing activities with these individuals, we're making sure that we not only account for the electronic information, but we also have a strategy for preserving and tracking the hard copy documents that may exist. So tracking on that is going to be a variety of forensic collection tools and an evidence tracking database that may or may not be in existence in your clients. Uploading that bulk data to processors. This is where we see a lot of data exchange, whether it be the collection process or uploading and sharing that information with vendors. You really need to be able to track when that data was moved. Chain of custody becomes very important, and needing to make sure that you have a lockdown, secure environment to be able to move information from one point in the process and one party to another responsible party or vendor. Again, we see this being tracked with spreadsheets and through evidence tracking databases, but also this is where you would look to your e-rooms to be able to look for any audit capabilities that they might have. And then finally, you get into the substantive review of the evidence, identifying what information needs to be produced, and then going through that production process and getting it out the door. So here in the review platform area, we're looking at the bulk culling of documents for potentially responsive material, and you're making calls on issues, privilege, and doing redaction during that process. This is an area where you're typically keeping track of privilege calls in a log or using system-specific tracking tools to be able to record your activities. Identifying the production documents and then producing those to third parties, this is where a lot of quality control comes into play. So making sure that you're able to track your quality control and understand beyond just a simple Bates numbering, do we have every document in the range? What quality control activities did you do? And then what was that authoritative gold copy of the data set that you sent out? So end-to-end tracking, we've talked about a lot of different activities that need to be tracked and many different techniques or tools that companies and attorneys use at this point. Is it possible to have end-to-end tracking? In an integrated system, yes, generally it is, but we rarely see people use integrated systems. Rarely can you have that one hammer that fits every nail. So we see people looking towards a best-of-breed system, or what a friend of mine refers to as the Bride of Franken system. Can you do end-to-end tracking at that point? Maybe, but you'll have work to do. And at a minimum, you need to be able to consider checkpoints around custodian identifiers. So if you're collecting from Ed Lee, is that the same as collecting from Edwin Lee or Edwin E. Lee Jr.? So do we have the right person? Device or source data type. So being able to understand, is this a laptop? Is it a shared drive? Is it a mobile device? What did I collect from when I collected from that individual? The collection method, so what technique did you use? The unique device or image identifier, so the source would be an identifier, and then that image that you've collected, oftentimes we want to barcode that and track it through the system. Finally, when it gets into more downstream processing, you want to make sure you're able to keep track of search terms, dates, or other subjective filter criteria. Key dates around which you took action. When was something identified as needing preservation? When was it collected, preserved, processed, filtered, etc.? And then file counts and history around that information. So what we're seeing lately is most companies face a non-integrated set of systems. They are using these one-off tools, but if you're thinking of your checklist of tracking tools today, if you're living in a world where you don't have that integrated system, I typically like to see somebody have a non-custodial data preservation log. I like to see IT keep track of when did they place a system on hold, when did they begin keeping backup tapes if that was their strategy, and what systems did they identify. I like to see a custodian-specific storyboard. So if we are dealing with information from Ed Lee, I like to be able to see a narrative for what did we do over time with Ed in terms of interview forms, miscellaneous notes collected in a packet. I like to see collections documentation, so evidence collection or chain of custody forms, file inclusion and exclusion reports. So many times you don't want every file on that particular person's laptop, you just want the user files. So I'd like to see what that file list is. Documentation of changes over time. So if you made different decisions about what you were going to collect and what you weren't based on scope, I like to see that documented. And then deviation from the norm. You may find that high-value executives you may need to take a more sensitive approach to versus line of business managers. And then finally, processing reports, deduplication reports, exception reports, those type things. And anything that comes from a vendor or third party, you want to make sure that you're able to make sense of how that fits with the rest of your preservation and collection documentation. So the next best alternative to an integrated system, even the most mature teams will face gaps in how they track activities during the process. The key in my mind is to use discrete tracking tools at each formal point in the process and then bring those together in a way where you can tie them back to unique identifiers for custodians, data source, and that image data set. When you have a consistent use of the unique identifier across all these process silos, your data and technical team can create a consolidated database on the back end to be able to do consolidated tracking and reporting. It's highly likely that you're going to have to pull this information together on your own. So one of the key players that I see emerging on litigation support teams really is a data analytics, data analyst person in addition to your computer forensics team. So from my perspective, one of the big things that you can do to be able to protect yourself and understand where things are is use a data room in litigation. My colleagues in the mergers and acquisition and transactional law areas have used a data room to be able to provide an authoritative answer to what happened when for years. I mean, it's nothing new to them, but we're seeing it emerge in the context of litigation. And I like to use a data room because it gives me ready access to the latest version of all relevant documents, whether it be a subpoena or information around requests for production or the documents themselves, the data and the evidence. It helps me avoid version control problems and that last-minute scramble to gather documents from a lot of different sources. It helps me make sure that the internal decision-making that our team engages in is visible across teams, so back to that idea of transparency, and it helps me control and monitor access to key documents, not just within my team, but also when we look at sending this information out to third parties. The selective access features for different stages and needs is also one of those key benefits, as is the clean transfer of information and that really solid audit trail that I like to see. So in context of those needs and the benefits, how do I use ShareVault today? I use it in the scoping and planning. So we look at collection and distribution of request intake documentation here. We also use it in the collection and preservation stage. So cross-country, international transfers of data sets in a secure manner that provides me a tight chain of custody. That's one of the key things I look to ShareVault for. Data processing, so when I need to exchange data sets among vendors, I can upload my key data set to my ShareVault environment and my vendor can pull it down. And then document production. Likewise, I can transfer that final gold copy of the production out to the third-party requesters, follow up with a cover letter, and I've just bought myself more time to do my work as opposed to having to get something in somebody's hands physically across the country at a certain day or time. I can put it in the ShareVault environment, give people access to it, and know that it's there.
Well, thanks, Ed, for the excellent presentation. We'd now like to have a short demonstration that shows how ShareVault can support eDiscovery process. And let me bring that up. ShareVault is a secure document sharing system, and it's been configured for this demonstration for a defendant company named Bravo Company. And Bravo Company is the defendant in a multi-district litigation. So the first entry into ShareVault is through the log-on screen, and I'm going to log on as the administrator, which would be someone from the Bravo Company or somebody they appoint to actually administer the ShareVault and all of the access and permissions for users and control of document access. So we log in, and if you have more than one ShareVault, you can pick the appropriate one. Here we're picking Bravo Company. And as we enter, you go through a confidentiality notice agreement. This can be configured and customized for your requirements. And this happens for each user that you've invited into the ShareVault. And now we are loading up the ShareVault. Here you'll see on the left side, we've organized the category of documents by tags. And you'll see that what we've done here is assume that there are several categories of documents that are collected documents primarily from within Bravo Corporation. We've also configured two categories of documents from remote sites, and this is to support the publishing of documents from remote sites with Bravo Company, and this allows what we call bidirectional publishing, which is a unique feature of ShareVault. This means that not only can the administrator upload and publish documents from the corporation, but they can also enable users from a remote site that have enabled and permission to upload documents as well. You also notice we configured a file called production files. So as a result of the review process, this is an area where the actual production data sets can actually be produced and uploaded, and then can be a permission for various third parties outside of the corporation to download. You'll notice that the way the files are presented here is by these particular categories. Very easy to look at a file. Here's one that opens up in the browser. You can actually open up multiple files, and you'll see that you can switch easily between files to review those. So I'm making this a very quick demonstration. If we look at a particular category, say remote site 1, you'll notice that it shows the organization of remote site 1 in terms of documents. As an administrator, I can see configuration options for this file. So for example, this shows that the file is in remote site 1. It shows that only the group site 1 is allowed to have access. It also shows that it was published by John James at ProSigma Services. So a good example of how you can easily look at the characteristics of each of the documents that have been loaded into the ShareVault. I'll go to users and groups now. This is where you set up your users and can group them into categories of groups which have specific access privileges. So for example, here you'll see that in Site 1 group we have 3 users that have been invited to that group. And if you double click on Site 1 group, you'll notice that this group's been permissioned to actually have access to remote site categories of documents. If you recall, in the original documents page, there was a category of documents for remote site. It turns out that in this case, what we've done, we've actually given the Site 1 group rights to actually publish documents into the remote site category. I won't show that now, but that's been done. It's very easy to create groups. We've created a number of groups. It's very easy to invite users. And for example, let's move June Walden as a user into the plaintiff firm 1. And if we double click on plaintiff firm 1, you'll notice that plaintiff firm 1 is allowed to have access to these documents. Notice that they don't have access to remote site 1. So lots of granularity in terms of controlling users, groups, and their permissions. And then the final function I think is important to realize in a discovery process is the ability to actually track the usage and activity within the ShareVault. So here I'll go and pick a date, let's just say July 10th, and you can configure reports dynamically here and interactively. I'll update this report, and what this will show is the activity in ShareVault. You'll see that as I scroll down, you can see that there are lots of logins. Here are downloads. For example, here's June Walden, who downloaded a document that's ID'd here. As we continue through this list, you can see all of the activity, logins, views, downloads, etc. So very powerful reporting tools that allow you to track and provide activity auditing. The last area I want to show is under the administration capability is the ability to actually set up policies that allow users to have certain access to documents. You notice we have our standard policies here, and I created actually a very specific policy to allow specific users to be able to download production sets. And so those download rights can be applied to the group or the users that are given those rights for those specific production set files. So I know this is very brief, but we wanted to give you an idea of the features that can support eDiscovery. There are obviously a lot more features that are possible, and if you have additional questions, we'll allow you to contact somebody at ShareVault, which I'll show now. And then we also want to entertain a question and answer session now. All right, one question is, will we send out a copy of slides after the meeting or provide a link so they can be downloaded? And the answer is we will be sending out a link of the slide presentation to all attendees. And I have a question here.
Yeah, so
there
was a question of are we aware of any commercially available software to track end-to-end all these activities? There are many different packages that have elements of tracking. Some of them are closed systems. Some are open systems, and when I say closed systems, you have to enter all the information into that system, and it's an automated way to manually track your activity, if that makes sense. So you go in and you log what you've done, and then the next step when you take an action, you go in and you log that again. That doesn't necessarily get you where you need to be at the end of the day. There are other open systems where you can import activities from your matter management system or from your forensic collection systems, or upload reports from your processing vendors. Those are a little bit more powerful, but again, I find that most of those have some sort of gap. So we are aware, and we do see clients using commercially available systems, but at this point, the unfortunate truth is they all have some sort of gap. There's something left to be desired.
We have another question. I'll read that for Ed to answer. What are the magnitude of eDiscovery costs today?
A lot of numbers are thrown around in terms of eDiscovery costs. We see a broad range in discovery costs, and when I look at discovery costs, I'm not just looking at price per page, processed and reviewed. What I look at is something kind of more comprehensive in terms of the scoping piece, the planning, the collection phase, all the way through getting that information out the door. When I look at the total cost of that, from paraprofessional time, inside counsel time, outside counsel, small to medium-sized matters, you're looking at typically around $200,000 to $250,000 a month, just in discovery costs. When you get up to large multi-district litigation, incredibly complex cases, it's not uncommon for us to see that collective cost run about $1.5 million per week. So when you look at the dollars that are spent, it's not just the processing per page, and I see the numbers of 25 cents a page, 50 cents a page, somewhere in there. That's not the number that I'm looking at. I want to see how many people does it take to get the job done from the time we talk to a person that we've got to collect something from all the way through we push that gold copy out the door. And the fact is, in large complex cases, you're looking at $1 million, $1.5 million a week, not being unreasonable.
Okay, another question. What are the differences in collection versus preservation strategy?
So that's a good one. We all know that as attorneys, we all know that the obligation to preserve something is much different than the obligation to go and collect it and then do something with it later. It may be early in the case where we have to make very quick decisions about preservation that we end up either determining that information is wholly privileged or is subject to some other reason that we wouldn't need to eventually produce it, so we wouldn't go through the collection activity. One of the things clients ask me about a lot is if I choose to do a preservation in place. So, for instance, I lock down my system and make it uneditable, but I leave it there. I don't go out and affirmatively collect and put it in the evidence room. What are the issues that I'll face later on? And a lot of times clients that make that preserve in place decision struggle with supplemental collection, supplemental preservation activities whenever scope changes. So I don't have an answer to the question of should I do preserve in place or should I do collect to preserve. I'll say that it depends on the matter, it depends on the systems you're dealing with, and that's why documentation, planning, and transparency is so key to your world whenever you get into this activity.
Thanks, Ed. Another question is, who is responsible for each phase of the eDiscovery process?
Courts will tell you that the attorney is responsible at the end of the day for all this, and that's an uncomfortable hot seat for us to be in. So we have to rely on a broader team. I look to I look to outside counsel to make the ultimate call at the end of the day, because they're the ones that inside counsel is relying upon as trusted advisors. Outside counsel doesn't always have, the answers that they need. They rely upon forensic experts. So there's a role of a forensic data expert to be able to bring ideas around collection protocol, preservation protocol, and then processing. So what do you do with that information to make it useful? They're going to rely upon somebody like that early on. Later on downstream, you have paraprofessionals or discovery specialists that will get involved, and they really get involved from a tracking, documentation, and project management standpoint. So while the attorney is ultimately responsible at the end of the day, we're seeing an increasing importance on forensic specialists providing their guidance and input, and then project specialists, paraprofessionals that really understand discovery process and know, what type of documentation is needed for attorneys to certify at the end of the day discovery was conducted in a thorough way.
All right. Thanks, Ed. This really concludes our webinar. I'd like to thank each of you for attending, and if you have more questions, feel free to contact us, and we will be providing links to the documentation. Thank you.